So the 3-to-1 ratio is you need to make 3 times whatever the rent is going to be. So if the rent is $2,000, the tenant needs to make 6,000 on a monthly basis, right? So that's the 3-to-1 ratio I'm talking about. It's customary to be a 2.5-to-1 ratio as well. So, and it gets to be a fine line there, but all I'm saying is that we need to be active as owners in the property and in the management, and not just let the management company tell us what they're going to do. Because sometimes, look, if we're at 100% occupied, we want to ensure that we're at that 3-to-1 ratio, even if we're not 100%. And that's just maybe MIA's standard practice. We're going to tell them we want 3-to-1. We don't want 2.5-to-1, because there's typically less problems with that, and it's going to ensure that maybe they can make their rent on time or make their rent at all.
Yeah, because some of these properties have RUBS, right? And so they're bill back systems, and they're not just 2,000 a month. It's like it changes, and it varies, and then it's billed back. So sometimes you're running, it looks like delinquencies, but it's like $23.17. Okay, $232. But you start getting, now they missed a rent payment. Now they missed two. Like, we want to catch it quickly, and we want to stop the bleeding. We want ideally everybody to pay and pay on time. We got to do what we say and say what they mean, what we say, and do what we say. I don't know what you said, but it was
good. Mean what you say and say what you mean.
And do what you say.
Right. And that really is it. The leases that we use are even like when my properties were in Georgia or New York or whatever state they were in, most of the times, any state that I have had assets in have used whatever state association, apartment association lease was recommended, because those are actually created by the attorneys that work, like the Texas Apartment Association. We have specific attorneys that are with it on those boards and have worked on these leases. The lease changed last year, but it changed to be a little bit more. It was already landlord friendly, but it became even more landlord friendly. So it really depends on the state that you're in. New York, they don't have an apartment association lease, so we had to have an attorney create our leases. And then along with the lease, you've got all the other addendums that have to be used. Like in Texas, we have the Public Utility Commission. So when we're doing bill backs or water allocation, we have to make sure that we have those addendums. And, even with the lease, there are parts of the lease that you can add, say, see addendum such and such, or you put a rule in there that applies specifically to your asset. The most important thing is know the contracts that our residents are signing, and then what changes do we need to make to them in order to best benefit our business plan and the residents? Because when you go to the court, like, the judge is looking at what is best for the situation, and we should be fair in what we're doing. And the only way to maintain a fair, consistent policy is to follow a contract that has been approved by lawyers that have been doing this and do this a lot more than like myself. These people are like true experts, and for the most part, there's a lot of times that I've seen people, start doing their own thing, and you're like, well, where does it say that? Well, it's in the contract. Well, no, it's not. You need to go back and read the contract. So I always read the contracts. They'll save you.
Well, what about legal, right? PM, what happens if it goes south with the PM and the asset management or the owners? And like, you're going to have legal that are helping us get these assets and close them. You're probably going to, maybe it's the same, maybe it's a specialized attorney that deals with evictions, right? So you know what it's going to cost you to get the notice and go to court, because you do have to show up. And so that might be a different attorney. Then not only are you having a tenant lease agreement, you're having a PM agreement. So if something goes south with the PM, what does the agreement say? And if something has happened that is outside of that agreement, usually there's a 60-day notice. Sometimes it can be 30, but usually that transition time, PM company exits, and now we have a new one coming in, or whatever that looks like. But you guys are learning what a good lease. You've probably been a tenant somewhere, a resident somewhere, and signed a lease. Then on the other side of things, what does the property management agreement look like when it comes to signing that.
In some cases, especially when you're dealing with residents, because it does protect everybody involved. And then the property management company contract with the ownership group as well. Sometimes, like putting all these things in writing also hurts us, because then it's if it's in writing, you should be following it. Well, I've seen it when we go to court and something happens, like, well, it was the matter of opinion, because that wasn't really written. So when things like that happen, when it comes to residents, I will tell you that the judge typically goes back to wherever the state law is, even if it's not written. There is a law somewhere that refers to the situation somehow. And so it's one of those things where, I always say, let's just stick to our standard contract agreements that have been approved through the attorneys. So that way there is no question in it. I am very process driven, or teach my people to be very process driven. And so what I will say to them when somebody calls me and says, hey, well, what can we do? Did you look at the contract? Did you read the contract? Because if it's written, then we use that. But the reality of it is, I always refer people back to the contract. If we have a landscaper, well, what in the landscaping contract did it state about, the canopy of the trees? How far up did they have to go? Did they have to go 7 feet? Did they have to go 9 feet? How far away from the buildings did it say that they had to trim? Did they have to trim? Did it say anything? It may not have said anything. So, then we just paid them $15,000, and guess what? They don't have to trim away from the buildings because it doesn't state it in our contract.